Hello and welcome to another Industry Careers for PhDs podcast brought to you by Cheeky Scientist. I'm your host, Isaiah Henkel, and today we will be talking with Craig Peterson on immigration issues for international PhDs. If you're interested in getting access to the full interview, as well as getting access to all of our job search materials, our complete job search blueprint for PhDs, and our private job referral network for PhDs, go to cheekyscientist.com/association to learn how to become an associate. If you would like these podcasts as well as our free articles sent to your email inbox, go to cheekyscientist.com and you can enter your name and email on the homepage, and these will be delivered to you as they come out. And of course, you can listen to the rest of these podcasts on iTunes at any time. So once again, we will be talking with Craig Peterson on immigration issues for international PhDs, and we'll jump in now. Welcome, Craig, and tell him how excited you are for this webinar today. Craig, again, thank you for being here with us.
Thank you. That's a very nice intro.
Yeah, well, you make it easy with your accomplishments. So, really appreciate you being here. You know, obviously we have a lot of PhDs, postdocs, some PhD graduate students on, and they always have a lot of questions about what their visa options are, especially relevant to people who might be in the sciences or in these advanced degree programs or after their advanced degree programs. So maybe we can just kind of do a brief overview and talk about what circumstances that people, I guess what the visa options are or the citizenship options are, and then what are the different circumstances behind all of them. And maybe we can kind of break it down into non-immigrant, so temporary visas, and permanent resident or green cards.
Sure. I wonder if you could, and maybe this is a guess on your part, but any idea how many of our listeners might be inside the United States right now or versus outside?
Yeah, great question. So if you're in the United States, why don't you type in yes? If you're not, why don't you type in no into the chat box? I can tell you in our association overall, we have the majority of our international PhDs. Actually, it's probably about half and half of our international PhDs. Half of them are in the U.S. trying to stay, and half are outside trying to come back or move in. On right now, it looks like the majority, though, however, are currently in the U.S.
Okay. That's helpful. Okay, well, let me just start with a quick overview of the different categories that we see most oftenly used by scientists and researchers and PhDs. On the temporary side, and this would apply, one of these is going to apply to those individuals that are already in the United States. Very commonly, the H-1B, which you mentioned earlier, and this is for people that are coming to work in a professional capacity. The H-1B permits, it's for what's called a specialty occupation. So a specialty occupation is a job that requires, as a normal minimum for entry into the field, at least a bachelor's degree in a particular field. So the most classic sort of an H-1B is a job as a chemist, and the individual has a degree in chemistry. So that's a classic H-1B. H-1Bs are used probably most commonly because, frankly, that's probably the easiest one to qualify for. The H-1B is limited in numbers. We'll find, for example, people that are working for private companies, and I understand that this audience may have a particular interest in moving from the academic environment into the non-academic environment, private industry, that sort of thing. A very important thing to know about the H-1B is that outside of universities and government research organizations and affiliated organizations, there's a strict limit on the number of H-1Bs that are granted each year. So we just got finished filing this year's crop of H-1Bs, and I would expect we're going to see about 250,000 or more H-1Bs went in during this past week, and only 85,000 of those can be approved. So that's the big issue with H-1Bs is can we get one even if we're qualified? So we can circle back to that if there are questions. Other common non-immigrant temporary statuses that we see is, for example, the J-1. This is an exchange visitor visa. And the purpose of this visa is to enable people to come from other countries into the United States in a variety of different capacities. There are, I believe, 13 different categories of J1s. There are students, there are professors, there are research scholars. There are other categories such as trainees and camp counselors and people simply working over the summer that are in academic programs in their home countries. And so it's used for a variety of different cases, but it is used a lot for scientific researchers. That's a visa that is operated by the U.S. Department of State. And again, its primary function is exchange. So the whole idea with the J1 is people come to the U.S. for a period of time, a particular purpose. And at the end of that program, the hope is that they go home and say good things about the United States. So it's a tool of public diplomacy is what it is. So the goal of moving from that university in the United States where you may have pursued a PhD or done a postdoc on a J1 visa into industry may get complicated by a feature that some J1 users have, this obligation to return home for 2 years before getting an H-1B or a green card, permanent residence. Sometimes that applies, sometimes it doesn't. So it doesn't, in a lot of cases, it does not apply at all. But we'll circle back to that as well. So then we see the O1, and this is for individuals of extraordinary ability. Extraordinary ability generally means people that have risen to the top of their field. And there's a variety of categories of evidence that the immigration agencies look at to see whether you qualify. They're looking at prizes and awards. They're looking at publications. They're looking at original contributions in the form of, it might be publications, but it might be patents as well. They're looking for discussions about your work in the scientific literature or in major media. They're looking for other indicators of distinction that might be a very high salary compared to others. So you have to have a few things. You've got to have information in several different categories to qualify for that one. And the O1, the way that is structured is kind of similar to a couple of the green card options that we see. And then we have a couple of others, the F1 student visa. So I wouldn't be surprised if several of our listeners aren't on the F1 student visa right now pursuing their PhDs. So the F1 allows just that, to pursue the academic program, but then after graduation, it also has an employment option called optional practical training. And people that have degrees in science, technology, engineering, or mathematics can first get 12 months of practical training, and then they can extend it for up to 24 additional months for a total of 36. So that's very helpful, particularly in these cases where it's difficult to get an H-1B simply because of the numbers. Another thing that we see, this is not for employment specifically, but people do come occasionally to do independent research, and that can be done under visitor visa. Doesn't allow for any employment, so it can't be something where there's a U.S. employer or even a foreign employer, but it permits research for up to 6 months. So those are the most common non-immigrant status. So non-immigrant essentially means temporary, people that are coming here for a particular purpose for a period of time, but are not pursuing permanent residence. None of those categories itself will turn into permanent residence. Some people think if I simply stay here a certain number of years as an H-1B that I become a permanent resident. No, that doesn't happen. Now, you can, while in an H-1B, and this is really, the H-1B is the best of these categories for people that do intend to seek permanent residence, because the H-1B has what's called dual intent. It can be used by people that intend to remain in the U.S. temporarily and then leave. It can be used by people that are actually in the process of applying for permanent residence. None of the others is quite as comfortable in terms of being harmonious with a permanent residence process. For example, the B visa for visitors or the F visa for students. These are visas that in order to get one and keep it, you must have a residence outside the United States and no intention of abandoning it. And so someone in one of those types of statuses that is going to launch a permanent residence process needs to understand that there are conflicts there. And sometimes it can be done if there aren't other options, but there are certain things that need to be managed there. So, and we can circle back. And I know that a lot of this session will be question answer, so we can certainly come back. Some of the permanent options that we see, in the terminology here, I'll go at this a couple of different ways. Some of you are familiar with these terms, some are not. EB1, and that is shorthand for an employment-based permanent residence option in the first preference. Okay, EB1 has a few different types of application. One of them is what's called an alien of extraordinary ability. It's a lot like the O1. In fact, it has the same categories of evidence, and the standard is described very similarly for people that, again, have reached the top of their field. So extraordinary ability, and then there's one called outstanding professor or researcher. That's also an EB1. And then the third kind is for multinational executives and managers. And these are people that work for companies that might be headquartered in the United States or might be headquartered abroad, and they have at least one subsidiary or branch office or affiliated company affiliated by common ownership somewhere else. And it's possible to pursue a green card through that. The nice thing about these EB1 categories, all three of them, is it is not required for the U.S. employer to first go and search the U.S. labor market to see if there are qualified U.S. workers. That process is called labor certification, and it is not required for any of those EB1 categories. So that's nice. The next one we see is the EB2. So again, employment-based second preference. You've got what we see there most commonly is the advanced degree professional. And of course, if you are with a PhD, you have an advanced degree. But it's more than that. It can be a master's degree. It can be a professional degree like a law degree or a medical degree or a veterinary degree. It can also be if the job requires at least a bachelor's degree plus 5 years of post-baccalaureate experience, that can be considered an advanced degree for purposes of applying in that EB2 category. So we see those, and this is where the national interest waiver falls as well, the EB2. So national interest waiver cases, they share this nice feature with the EB1s in that no labor certification is required, so no requirement to show that there are no qualified U.S. workers. In fact, that's what's being waived in the national interest waiver. The waiver of the requirement to have a labor certification and even the requirement to have a job offer. So those things are waived in the national interest waiver. And let me backtrack just a little bit to EB1. The extraordinary ability type of application, that does not require a job offer either. So none of the EB1s require labor certification, and the extraordinary ability category goes further by not requiring a job offer. The other two, the outstanding professor and researcher and the multinational executive and managers, those both require permanent or at least indefinite job offers from the U.S. employer. Okay. As does the EB2 advanced degree professional. That requires a job offer. The national interest waiver does not. There's also an EB3, and these are for professional and skilled workers. Certainly you can do that if you have a PhD or an advanced degree, but generally the EB2 category is going to be preferable in most cases. And of course the EB1 is even more preferable. Now, there is some of you that are from India and China are wondering, why does it take us so long to get through this whole process where a person from Canada or the UK, for example, might be able to go through much more quickly. And this is a structural issue with the U.S. immigration system. With the green card process, the permanent residence process, there are 140,000 new ones available each year. across all of the categories. Okay, so there is a fairly large proportion, 28%, almost a third of them are set aside for these EB1 categories. And because not that many people qualify under any of the EB1 categories, they don't use them. So they never run out of EB1s simply because people don't qualify. Now, so the ones that don't get used, they do spill down to the next category, the EB2, so that increases those numbers. However, we do see more people that do qualify for the EB2 categories, okay? So aside from dividing the total number of 140,000 up between these categories, we have a further division. There are per country limits. And so the nationals of any given country cannot claim more than 7% of the total quota. Okay? This is where our problem and the real disparity comes in, because we don't find our permanent residence applicants coming from around the globe in equal numbers distributed everywhere. There are definite patterns. There are many, many more applicants from India and China than there are from Iceland or Cameroon, for example. So, Iceland and Cameroon, they never approach using 7% of any of these categories. But from India, they do. They exceed it every year. And what happens when that 7% quota is reached, that's all the people from India get that year. And that means that they go into the queue, and this queue has gotten to be very long, and they wait until they reach the front of that queue before they can take the last step toward permanent residence. My website is on there. It's sort of old now, but I've got a blog posting on this about why some people take longer than others, but it's still accurate. So if you want to look at that for a refresh, that's good.
No, that's great. And I'm gonna jump in real quick because we have some specific questions, and I want to touch on a couple of the most frequently asked questions. But I will remind, for those of you that are on here, go to www.opimmigration.com. You see the URL below Craig's picture. Some good resources there. So thanks for that overview, Craig. I really appreciate it. A lot of listeners they don't really understand what the different options are. Certainly, they have a hard time figuring out which options are best for them. First, I want to ask, just overall, Craig, and I know it's on a case-by-case basis, like you just said, what country you come from and so forth. But if you are an international PhD, you want to work for a company in industry, on average, what is the fastest, the most effective way to make that happen, one way or another? I mean, besides getting, married or whatever, but in terms of finding an employer to sponsor you, like what? Let's just go right to the heart of the matter. What's the best practices?
Well, the first option is the H-1B. That is, it's more cost effective than some of the other options. There's a little bit less work that goes into it. So if an H-1B is available, either because we're filing, right now at the start of the season, or if you're going to work for a university that's not subject to that annual limit, we always look at the H-1B first. And that can be arranged in as little as 30 days or less. So that's faster than the other options, and is cheaper. When that's not available, though, for private industry jobs, as most of the year it isn't, we have to look at other things. So the other thing that we would first look to is an O1. So do we have enough in terms of publications and distinctions to support an O1 application? Another thing we could look at, and this is actually cheaper, but it's a little bit of a conflict. The J1, as I mentioned, has this trainee option. And if a person has completed a degree outside of the United States, it is possible to come in for on-the-job training at a U.S. employer. Now, this isn't for the purpose of keeping that employee long term. That's not really the purpose of the J1. It's to send people home. But if simply getting some skills and exposure to the U.S. employment market and working at a U.S. employer is the goal, then the J1 can facilitate that. So we look at the H-1B first, and then we look at the O, and we might look at the J, depending on what the goals and requirements are.
Well, let's flip it around, because we're always encouraging the attendees to look at it from the company's point of view. So let's say I'm an employer, and I want this candidate bad, and I'm going to do whatever it takes. Money's not an issue. What's the fastest way to get them hired and their international PhD?
It's still an H-1B if they're available, and the O-1. And if I'm the employer, I really want that person, and I want to keep them. It would be in that order: the H-1B and the O-1, and then the J-1 if we can't do anything else.
And there's no other option outside of that, even for permanent residents. It all has to go through.
Sure, there are, but then you have to drop the word fast. So if we have an international PhD who's outside the United States, even if we're really good and we've got lots of publications and distinctions, and we would qualify for the EB1 extraordinary ability, it's going to take a month or more to put that together and file it. It is possible to pay a little extra money for expedited processing and have them, the immigration agencies, look at that in about 2 weeks. That sounds fast, but getting that approved does not enable someone to simply enter the United States. That's what's called the petition. But after approval of that, when we have someone who is outside the U.S., that approval goes to the U.S. Department of State, and then we start what is probably a 6-month process to set someone up for an immigrant visa at the U.S. consulate. So nothing fast about that, really. Not faster than the H, and it's not faster than the O1.
So it's 6 months still, even if it's
at least,
processing.
Yeah. Right. And this is for people outside the United States. Somebody that's inside the United States, there is a different option for finishing up. We still have the same requirement to file a petition. We could probably get it expedited with an extra filing fee. But then there's something called adjustment of status, and that is changing a person from whatever status they have in the U.S., let's say it's an F1 or an H-1B, into a permanent resident. And then that's much more stable. The person can keep working. They have access to a different...
Oh, great. So if they're already in the U.S.,
there are advantages.
More options. Okay. And
provided. Now, again, let me just back up. We have these, if you're from India or China, or we're applying through the EB3 category where we're out of numbers, you can't finish the process. You can file the petition, okay, but the petition doesn't grant anybody any additional right to stay, nor does it provide work authorization. So this is where these per country limits raise their head again, and it may or may not provide anyone with any additional abilities. They may still be stuck with moving into an H-1B or an O-1 to extend their stay.
Okay, so if I have a worker here that's from India and I want to keep them no matter what, my best option is an EB3 or an HB1 still.
Yeah, I'm still right, because we still have to figure out, how do I keep that person legally inside the United States? How do I keep that person employed? So most commonly, this individual may have completed a PhD in the U.S., so they're most likely on an F1 visa. So again, you can get probably up to 3 years if we're talking a scientific field. So we can get that on the student visa. But then what we're trying to do, though, at the same time, is we're trying to get an H-1B. So we may file, and as I said, about 250,000 will be filed. Only 85,000 can be approved. So they run this by a lottery. So they take the 250,000, they pull out 85,000 to process, and the rest of them get sent back to the petitioner.
And no amount of money can overcome this.
No, not that. No,
okay.
No, that is simply embedded in the law, and maybe we'll see a revision of it. But as for now, it's been that way since 1990, actually.
Right. One question that came up, that premium processing, was it suspended by the new administration or not?
It was suspended, but only for H-1Bs. So it's suspended for those applications starting April 3rd, so this Monday. Premium processing is still available for O1s. It's still available for some permanent residence applications, but not H-1Bs.
we talked about the caps, I think, on the O1 and a few others. Who decides whether, so for the OPT, the job must be related to a major or field of study. Who decides whether your major relates to that job or school? So who's making those decisions? It's the government, correct?
Well, they don't really look very closely at that. In the initial instance, it is what's called the designated school official at the school. They're required to recommend practical training. Those DSOs may or may not inquire into what kind of job a person has lined up. In fact, you're not even required to have a job lined up to apply for OPT and receive it. So it generally doesn't come up. However, it certainly is a feature of practical training that the work is related to the field of study. And so in a case, for example, where someone is mid-OPT and they go home and they have to apply for a new visa, they go into the consulate and the consular officer may ask about what kind of job are you doing. At that point, the consular officer could say that job doesn't relate to your field of study, so you don't get a visa. That conversation could happen with somebody entering the United States during their practical training. So it could come up at various junctures, but at the initial threshold of applying, it typically isn't asked.
Thank you. Going back to H-1Bs, why can't academic, and this is from Prachi, why can't academic H-1B be transferred to an industry H-1B, or can it?
Well, sometimes it can. Now, keep in mind the academic world is not subject to this annual limit on H-1Bs. So the university of wherever can get an H-1B anytime it wants to. That limit of 85,000 doesn't apply to them. But if we are going to move from academia, where we don't have that limit, into private industry, where we do have that limit, well, there has to be an available H-1B. So that's usually the problem. There is if somebody wanted to move from the University of Minnesota, where I am, to a private employer, well, if we've missed the deadline for filing, they've all been used up, there isn't one to apply for. That H-1B can't, it works fine at the university, but not outside. Now, one exception to that is something that's called concurrent employment, and this is where people have two H-1Bs, and this is possible. So if you have an H-1B at the university and a private industrial employer files its own H-1B, so long as the individual maintains employment at both places, then that private industry H-1B can be used. But it can't be used beyond the expiration. So we have to have concurrent throughout. So when the university's H-1B expires, then the H-1B for private industry would also expire. But some people have been able to do this by having a part-time university job and a part-time or even full-time private industry job, but it requires both of them together. Until that point where that private employer can get an approved H-1B in that year's annual quota or the next year or whatever it may take.
So, okay, that was going to go in my next line of questioning. So let's say a university sets up a collaboration with a company, which does happen in various forms and is dependent on the university. If you are on a university H-1B, which again, there's no limit, you can work at that industry company as part of that collaboration, and, even though you're not approved for industry H-1B. That's what you're saying, correct?
Well, you would have to, if the university is the petitioner, you can work for the university. Now, there might be some collaboration with a private company, but the employer and the source of the payroll, all of that has to be the university. This annual cap has some exceptions as well, and this is for in a collaboration scenario like you suggested. If an individual working for a private employer is working at the university, not employed by the university, but working at the university in some collaborative project that is somehow closely connected to the university's research or teaching mission, then that H-1B could be considered exempt as well from that annual limit. So there are some cases where a private employer that's typically subject to the cap because of the nature of the job or the project might find a way to get around and be exempt from the cap for that particular role.
Thank you for joining us for another Industry Careers for PhDs podcast. If you're interested in attending one of these interviews live, or if you're interested in getting access to the full interview, including all of the background materials and show notes, go to cheekyscientist.com/association and learn how to become a associate. You can get on the waitlist for the next association enrollment period there and learn full details about the program. It's a program specifically designed to help PhDs transition into top industry positions. If you would like to receive more of these interview highlights via our podcast sent directly to your email, go to cheekyscientist.com and email subscribe under where it says Start Here. If you haven't already, you can also subscribe to this podcast on iTunes. Until next week, remember your value as a PhD and start thinking and acting like a successful industry professional.